Hi, this is Erica Marilyn. I'm the founder of Perfect Legal Video, and I'm very excited to bring to you today Attorney Nicole Reeves Lavallee. She is an amazing family attorney. She has her own firm out in Worcester. I'm really excited to talk about today's topic, which is a four-way meeting. So let's talk about that. Welcome to the show today, Nicole. And what is a four-way meeting?
Well, first and foremost, get your mind out of the gutter. It's not that. A four-way meeting is essentially a meeting with parties that are in litigation. So you have the plaintiff, defendant, and their respective counsel. So it is four ways, meaning four people involved in this meeting so that they can try to resolve issues.
My mind is never in the gutter. But I get it. So you've got a couple people at the table on each side. And what happens if you don't have an attorney?
Then we basically have a four-way meeting that is a three-way meeting. So the same thing would apply. You'd have the three people there trying to negotiate and come to terms. So it doesn't matter if there's a little less. It doesn't matter if there's more. Sometimes you have more people involved as well.
Can you bring other people to the meeting as well? Like maybe you have someone who's like a witness to things, or maybe helps you mediate things in your own life besides your attorney?
No. The meeting is simply for the party. So if there is another party to the complaint, so let's say it's a guardianship, so there might be mom, dad, and guardian, then you might have a five-way or even a six-way. Or you might have something where our counsel's involved and they're appointed for the child. So that person might come in. So obviously it can grow, but it's going to grow based on the party. So if their name isn't in the caption and or their attorneys aren't involved, then that's basically what it's going to be. So it's limited only to the parties that are listed in the caption and their respective attorneys.
So it sounds a little like mediation. They're trying to work through issues. How is this different than a mediation?
Very simple. There's no mediator. It is the parties and their respective attorneys. So you don't have that mediator that is theoretically going to work toward an agreement. You have just the four people, arguably, that are going to sit there and try to negotiate. So sometimes, even in a four-way meeting, we're going to take each other outside. I'm going to take my client outside. I might just take out the attorney and talk to the attorney directly, so that we can, again, negotiate a little bit better without everybody being present. But the goal is that everybody's going to sit in the same room and we're going to hash it out. So you're going to say what you like and what you don't like, and then I'm going to listen to the other party and what they like and what they don't like. So we're going to listen to all those things, and the attorneys and or the clients are going to come up with creative ways to see how we can resolve it. Sometimes it's really simple, and sometimes we have to be very creative.
I actually like thinking about this. I've been through meetings like this in the past. It tends to be, I think for a lot of people, a high anxiety situation. And those meetings, they can get pretty ugly.
They can. The goal is that they're going to be happening in person. So we're not going to have, we're not going to be able to see your reaction. We're not going to be able to see where, you're saying something. If you're on the phone, I don't know what you're reacting. When you're sitting there and you're looking at me or you're looking at the other side, I can see whether or not it's, causing you more stress, or I can see that you're going, I'm saying yes, but my body is saying no. So we as attorneys are going to interpret that. I'm not going to enter into an agreement where you're not fully comfortable. So it's one of those things that we definitely have to consider. I get that the anxiety is high. That's why you have an attorney. So you literally tell me, Nicole, this is what I want. This is what I'm willing to do. This is my bottom line, whatever that may be. And then realistically, in an ideal world, you're going to go in and you're going to sit there and look pretty. And that's your only role, just to sit there and look pretty. You're not going to show emotions if you can possibly not do that. You're not going to get angry. You're not going to really have to say anything. That's why when I go, okay, now, Erica, let's come out. Let's talk about this, because I know that this is what you said the bottom line is, but this is where they're at. Are you willing to budge off of that? Let me and your attorneys do that talking, rather than you going and talking to your ex, because that's never productive. That's the reality. Is there's a reason why you separated, for whatever that is. And so, you two know how to push your buttons. So again, as the attorneys, we're going to kind of do a little bit of the mediation, without call it mediation, and take a step back and go, okay, but this is my client's respective position. No, this is my client's respective position. And again, kind of go from there.
So what are the hottest topics that are discussed during these four-way meetings?
It's going to be anything that's in the underlying complaint. So if you're going for a divorce, obviously we're going to have to deal with division of assets. We're going to have to deal with any liability issues, and we're going to have to deal with children if there are any. In a modification, what are we seeking in the modification? Are we seeking a change in the parenting schedule? Are we seeking an increase in child support? What does that look like? So we want to go back to the complaints and or the counterclaims and say, what is it that you're looking for? So we're going to go to the last paragraph that says the wherefore. And the wherefore says, I'm looking for more child support, and I'm looking for a parenting schedule that works for the parties because the one existing doesn't. Okay, those are the topics we're going to talk about. Or I want to talk about the taxes, and I need to claim the children on taxes every year. So whatever that wherefore says in the answer or counterclaim are the things that are going to be discussed. Now, can we arguably discuss other topics? Sure. But the court isn't going to force an agreement on anything other than what is actually asked for. So we can agree on additional things that maybe came up after we filed the complaint, or hey, now that we're talking about this, why don't we talk about that, because it makes sense. So we can do that, but the court can't make us reach a resolution on those particular issues that are not sought.
That makes sense. And one would think that going into a discussion like this with your own representation and your and your ex having his or her own representation, you would think that you could really work things out. But what if you don't? I mean, I can imagine that there are just some issues that don't get resolved, and people just have a hard line no on what's being asked. Have you seen a lot of that, and what do you do?
Well, a four-way is a required thing. So let's start there. We're required to have this four-way. The court, every time you get a pretrial notice, says you must attend this four-way meeting. So it is something that is mandatory. We have to sit through it. So sometimes four-way meetings are 10 minutes because we can tell the judge that we addressed each one of those issues and the answer from the other party was no. And sometimes they're going to be longer in length. So the ultimate goal is obviously to reach an agreement. But again, if you're both taking a hard line, we're doing it because we're satisfying a court order. And obviously you should go in there with a little expectation of give and take. But again, I can't force you because you're entitled to your day in court. So that's why as attorneys, we again try to come up with creative ways to resolve the issues based off of what both parties are seeking. But sometimes that doesn't happen. And in which case you're going to have your pretrial hearing, and the judge may very well give us some insight saying, hey, I think it should be X, Y, and Z. And that's really when you should kind of take it back to your attorney and go, well, should I really settle for X, Y, and Z? And make that determination at that time.
I mean, it is nice when they give you those hints up front, isn't it?
It absolutely is godsend sometimes.
I mean, some people just aren't being reasonable. So it's nice. It's almost like, a smack to the head, and you're like, oh yeah, okay, I get it now. So if you do resolve some of the issues, what happens then? Is it just thrown out of court, or is there like a hearing just for the things that you didn't resolve?
So it depends on what kind of case it is and whether or not it's contingent. So certain things are going to be, hey, I will give you this, but if we don't resolve that, then all this stuff is off the table. So is it going to be, hey, I'm willing to settle for these things, or are there conditions? Assuming there's no conditions, then chances are you're going to go into court and either enter it at the pretrial as either a further temporary order or a partial stipulation. Maybe you let the judge decide that one remaining issue that the two of you can't agree on. Um, well, it really depends on whether or not, again, that's the contingent. So assuming that we have an agreement, in which case that the parties are going to say, yes, we will let the judge decide, then we'll enter it as a partial stipulation. Maybe we let the judge decide on that final remaining issue that we can't come to an agreement on. Maybe we enter it as a temporary order or further temporary order, and then at the time of trial resolve it to a final judgment on a partial stipulation, and again let that judge decide the final issues that we can't resolve. So there's a lot of things we can do. Now obviously if there's strings attached and it's, hey, I'm only agreeing to this if you agree to that, then there's no deal. So the stuff that you agreed on in a four-way are moot, and you're not going to start all over again. Now it doesn't mean you're not going to come up with that same agreement when you finally do reach an agreement, but maybe the other party's not willing. Maybe the other party needs to listen to that judge who's going to tell you exactly what their opinion is. And then you're going to go, oh, I guess I really have to give in. So again, things can change where that offer may very well come back on the table at a later point in time.
Well, I mean, that's very helpful. Do you have any tips or tricks that you want to share? Any stories that have to do with four-way meetings that might help the audience?
I think the biggest thing is, again, tell your attorney exactly what your bottom line is. If you have something that is a sticking point, let them know what it is. Let them know what terms you're willing to do. You know, obviously you're telling me, hey, look, the child support number, the lowest I'm willing to go down to is $200. Great. I'm going to start at $250. But let me do my job. But I need to know what that bottom line is for you. So again, tell me where you stand, and tell me how firm you stand on certain things. I see all too often that people go in and I look at them and go, wait a minute, you just told me something different, but now you're willing to settle. So I have to take you aside and go, is this something you really want to do? Or do you feel like you're being bullied by the other party? And sometimes it might be just, hey, I never thought about it that way, and my ex really brought up a good position, and I really am willing to do that. And other times it's, I really thought I had to answer because the attorney was really giving nasty with me. So again, I need to know from you whether it's something you're willing to move on. And certainly you have every right to speak up. I encourage you to do that. But communicate with your attorney as to why all of a sudden there's a change, because we're going to be looking at that going, what's going on? Is there something that they're not telling us? Is there something I need to know? So first and foremost, educate your attorney on your position. Second, go in there with the expectation that it's perfectly okay to stick to your guns, but it's also perfectly okay to go, hey, I need to move. If you go in there with the attitude of, I want what I want and that's it, then nothing's going to get resolved, and that's fine, but it's going to cost you a lot in attorney's fees.
That is sage advice as usual. And for anyone out there that is watching, that is going through something similar to this, they're heading to a four-way meeting and they don't have a fourth to protect them, please give Attorney Nicole Reeves Lavallee in her office a call. Her staff is amazing. She has incredible strategies for this. She does this every day. And so who better to get advice from than Nicole Reeves Lavallee? And she works with all family matters too. So please keep her and her staff in mind. They will not disappoint you. Thank you so much for coming on today, Nicole. We really appreciate your knowledge and your time.
Thanks for having me.
You are welcome. Have a wonderful weekend, everyone, and thanks for watching.